Let us start.
Jitendra sir, please start the session.
Good afternoon, friends. I, on behalf of Diet Test Committee of GCP, I welcome all of participants in the weekly meetings on the recent judicial presence on diet taxes. We are fortunate that we have CA Prakash Sinha between us to give us deliberation on the subject. I also request all of you to make this session interactive and put your question before our learned speaker. CA Prakash Shri is well known to us and do not require any formal introduction. But as a customary, it is my duty to introduce him. CA Prakash Siraj, FCA, is about 48 years, is a senior partner of the firm. He has post-qualification experience of about 25 years. During the passage of time, he has developed himself in the taxation advisory and litigation services, business advice services, management consultancy services, covering the whole corporate and commercial matters and regulatory issues. He has got the experience and expertise in FEMA, corporate law matters, taxation matter, including the international taxation and transfer pricing matter. He was a member of research study group constituted by NIRC of ICI on the international taxation and WTO matters. He has successfully completed the certificate course of Institute of Chartered Accountant of India about international taxation and transfer pricing, diploma in information system audit, DISA. Further, he has completed the course of IFCA, International Fiscal Association, Delhi chapter about international taxation and transfer pricing. He has completed the LLB and advising the client in various legal and regulatory matters. He has handled various assignments successfully in the area of firm practicing. Now, I do not want to take much more time. I introduce Mr. Prakash for his delegation.
Thank you, sir. So, ma'am, shall I start?
Ji, sir.
Please, sir.
Okay, thank you. Respected office bearer of Global Chamber of Professional, Asa ma'am, Jitendra Sharma sir, C. Ram ji, and all our participants who have joined, ladies and gentlemen. This is my privilege that I am here to discuss some of the important case law. When we try to select some case law, our efforts is that we will select a case law which is totally relevant. When relevant as well as which is very current here, we will not try to go back here. However, after finalizing the case law, we have finalized the 4 case law. The Supreme Court the Honorable Supreme Court has announced recently one of the important judgment, and this judgment is on the software royalty, whether the payment for the software charges is a royalty or not, as per the Income Tax Act. And this is one of the most litigated area coming from various high court, and it was reported the case was Engineering Analysis Center of Excellence Private Limited. This case is very much important here. Why? The reason is that the stake of the tax stake in this case, as I understood, was more than 25,000 crore. More than 25,000 crore. This means it was twice the Vodafone involvement. And moreover, it was not one SSE case. Their line of the SSE was there. Even the department was there. And this case was one of the landmark judgment that I will say by Justice Nariman, because the case was the impugned order. In fact, the department as well as SSE was arguing, and this case was flowing from 3 directions. First direction was from the Karnataka High Court. So one pillar was that Karnataka one pillar was Delhi High Court.
ये वॉइस ब्रेक हो रही है बीच में या सिर्फ मेरा कनेक्शन में इशू है?
प्रकाश का नेटवर्क इशू है।
नेटवर्क इशू ही है, सर का लॉग आउट भी हो गया है।
Yes, I think network issue is there.
Am I audible, ma'am?
Yes, sir.
Sorry, I lost this connection, and therefore I hope that now I will go in uninterrupted here.
Yes, sir.
This case is a landmark case that will be, and I am telling you that it will be remembered for a long and long, just like Ajadi Bachao case, just like Vodafone case. And there is a reason for this amendment here. It is one of the case which discuss lot of issue. It discussed Income Tax Act. It discussed about the direct DTA, different country DTA. It discussed about the copyright law. It discussed about the end user license agreement that we. And apart from this, there are certain principles that has been established in this case. The first principle that will be discussed, when a section is called a clarification section, when an amendment is added, when it can be said that it is an amendment, this amendment is a clarificatory amendment, or this amendment is a not clarificatory amendment. Because the moment it is a clarificatory amendment, we can see that this can apply with retrospective effect. But when the amendment is not a clarificatory amendment, it will apply from the prospective effect. The second case that we will discuss here, what is the term copyright? What is the term copyright, and how the term copyright under the Copyright Act is different than the term license under the end user license agreement. Third thing that we will discuss, what was the doctrine of sale, first sale, and the doctrine of exhaustion. This doctrine is something different. We will also discuss that part here. Further, we will also discuss what is the effect of the OECD commentary in the cases here. What is how the OECD commentary has to be interpreted here. And last, we will discuss what is the effect of the reservation when a country takes on the OECD country, like India has taken a lot of reservation. So what is the effect of this reservation here? So let's start with the discussion with this part here. And I'm right now, I will start with my slide PPT presentation here. If anyone has some issue, they can very well raise the issue, because I know that this case is not easy to grasp, but I will try my best so that everyone should understand this case here. First of all, in this case, the Supreme Court has classified, or in fact classified, the transaction into 4 parts. First part is that when the end user, who is in India, who downloads some software from the foreign non-resident here, and for this purpose, after downloading, some amount is paid. If suppose that I am the end user of some downloaded in my mobile, and for this purpose, if I have paid some charges, what will happen to that charges, whether that will amount to subject to the tax or not? That's the first charge. First is that
सर आपकी स्लाइड शेयरिंग स्टॉप हो गई है हाँ अब आ गई फिर से
second case is there. Indian company, there is an Indian company, lot of foreign company who incorporates a company in India, and that company works like a distributor here in India. That company purchase the software from their parent company and supply the end user in India. Suppose that you want to purchase some Windows software, you went to the Nehru Place, you purchase some software from Nehru Place shop. He supplied you the or IBM shop. He supplied you the software. You have brought the software in anything here on the CD or downloaded the CD, and after that you have installed that part here. What will happen to that part? And since you have paid to the Indian person or Indian seller, you have paid to the Indian seller, and the Indian seller has in turn paid to the foreign vendor here. Third case is that when the vendor is outside India, foreign vendor being distributor, purchase the software from the manufacturer, and after that he supplies to you. And fourth, most important part is that when software is supplied through on the hardware, we have seen that lot of machine that has been supplied to us. Suppose that Jitendra Sharma Saab want to purchase a Tesla car, and he orders the Tesla company to, okay, you ship the car from the Tesla USA to India. And after that, he purchased a Tesla car. What he has purchased? He has purchased the software in the Tesla car, or he has purchased the Tesla car per se? Can we say that no, he has purchased the car? If he has purchased the car, so the So the software is built into this part. The software is embedded into this part, because now lot of company, lot of car comes with the software. Or is suppose that if you purchase a mobile, lot of mobile, the mobile cannot run without the software. What we have purchased? We have purchased the mobile phone, or we have purchased the software. So most important part that is there. Then the issue will arise here, whether the question software charges is royalty under Income Tax Act or under the DTA. And as I mentioned that there were several cases which were coming from the
आई थिंक थोड़ी प्रॉब्लम फेस हो रही है. हाँ.
नेटवर्क इशू है पता चला.
after that, we will discuss the section 4, section 5, and section 9, which is important here. We will also discuss section 90 and section 201. And one more important case that will be discussed, that is the section 90, subsection 2, explanation 4. What the section 90, subsection 2, explanation 4 says, that if any term which is not defined, which has been defined into the DTA, we have to refer to the DTA that is there under the section 90, subsection 2, explanation 4. And it further says, and it is supplemented by the Article 3.2 of any DTA, that is the UN OECD model or UN model, that says that if any term which has not been defined, which has been defined into the DTA, that will go for the DTA. If it has not been defined, then we will go for the Income Tax Act. Azadi Bachao Andolan is quite clear. Then we will discuss about the section 195, who is the person who is required to bear the tax, and the Pilcom case also. The Pilcom case is something mistakenly typed. A Pilcom case was based on the 194E, 115 BBA, and how the Pilcom was distinguished in this case. As we know that in the case of Pilcom, the Supreme Court has held that section 195 does not apply to the Pilcom case. It is covered under the 194E. When it is covered under the 194E, the tax has to be deducted at the rate which has been specified under the 194E. There is no need of going to the section 195, and it is the section 195 who talks about the rate in force, and the subclause 4, section 2 subclause 37A, which defines the rate in force. Subclause 3 talks about that for the purpose of TDS, we have to go for the DTA rate. So it is the section 2 subclause 37 which talks about that what are the rate that has to be adopted. So therefore, there is a difference between the Pilcom case and this case here. We will discuss, and the Supreme Court in the first para itself, in the first few para, has itself distinguished that case with this. Am I audible, sir? Sarma sir?
जी सर जी सर.
जी सर.
Very good, sir. Please keep me reminding, because sometimes I feel that there is some problem in that part. The another law that will be discussed about the
वॉइस ब्रेक हो गई है फिर से.
पता नहीं मैम क्या हो रहा है सिस्टम में। आई एम
कभी कभी हो जाता है सर, टेक्नोलॉजी के प्लस माइनस दोनों होते हैं ना।
आज ये नहीं चाह रहे हैं कि हम टेक्नोलॉजी के केस डिस्कस करें, बट मैं हार मानने वाला नहीं हूं, मैं वो
आज हम तो
डिस्कस करूं।
टेक्नोलॉजी का केस डिस्कस करके ही रहेंगे।
हाँ।
कोई नहीं सर, स्टार्ट।
सो व्हाट इज कॉपीराइट, व्हाट विल डिस्कस द कॉपीराइट क्या होता है। वी विल आल्सो डिस्कस कॉपीराइट में सेक्शन 14 इज वेरी मच इंपॉर्टेंट ऑफ द कॉपीराइट एक्ट, एंड सेक्शन 14 में कॉपीराइट में कौन कौन सा कॉपीराइट एक्ट है और क्या क्या पावर है कॉपीराइट में, वो यहाँ पर डिफाइन किया गया है, और किस राइट को कहा जाता है कॉपीराइट। तो इसलिए सेक्शन 14 इज मोस्ट इंपॉर्टेंट। एंड सेक्शन 14 का टू पार्ट है, 14(1) एंड 14(b), 14(1)(a), 14(a) एंड 14(b, एंड
सर वॉइस, हाँ
what is the license under EULA, what is 195. Let us start with this case here. Now I am coming with the starting of this case here. In this case, the appellant, that is the EAC, Engineering India's Center, is the resident Indian, वो Indian resident है, end user है of the shrink wrap computer software, जिसने की shrink wrap computer software directly imported from the USA. The assessment starts for the assessment year 2001 and 2002 and 2002-2003. The AO, by its order dated 15/5/2000, after applying the Article 12(3) of the double tax DTA between India and USA, and upon applying the 916 of the Income Tax Act, found what was in fact transferred in the transaction between the party was the copyright, which attracted the payment of the royalty, and thus it was required to deduct the TDS as per the Income Tax Act. So it is the AO first observation. The matter is appealed before the CIT, and CIT dismissed the appeal on 2004. The appeal went to the ITAT, and ITAT relies on the Samsung Electronics case that was there, and in the case of Samsung Electronics case, ITAT allows the appeal here. Then matter came before the High Court. In the meantime, matter यहाँ से दिल्ली से सुप्रीम कोर्ट से जी का केस जा चुका है उनके पास। तो यहाँ पर दो क्वेश्चन आता है, that was for the purpose of decision के लिए है, whether tribunal was correct in holding that since the SSC has possessed only the right to use the copyright, the software, and not the entire copyright itself, the payment cannot be treated as a royalty as per the double taxation avoidance agreement. Or second case is whether the tribunal was correct in holding that the payment partakes the character of purchase and sale of goods and therefore cannot be treated as royalty payment as per the Income Tax Act. वो matter Supreme Court that goes against the SSC, and this SSC is here in Supreme Court. And now see what is going on in Supreme Court. Please see what is going on Supreme Court. Supreme Court में argument कैसे हो रहा है? First argument starts होता है from Mr. Arvind Datar, who is the well-known advocate, senior advocate, and how the Arvind Datar argues this case. Arvind Datar is arguing the case for the IBM India. IBM India argues that it is a resident Indian manufacturer of the computer. IBM India argues that it is a resident Indian distributor of a computer software products purchased from the IBM Singapore, which purchases off-the-shelf copy of the shrink-wrapped computer software. there are two type of shrink wrapped computer software का मतलब ये हो गया कि off the shelf computer software जो कि available है market में. It is not the customized software. It is a shrink wrapped computer software from a foreign company in Singapore for onward sale to the Indian end user under a remarketer agreement. What is there? That is a remarket agreement. He states that that is the argument is that he states that the IBM India is a distributor and not a party to the EULA, that is the end user license agreement between the IBM Singapore and the ultimate end user. Whenever we download any software, we enter into the end user license agreement, and this end user license agreement is between the user and the software manufacturer, that is the foreign company. The Indian company is just like a distributor. The Indian user pays the IBM India, and it in turns pays IBM India pays the amount to the IBM Singapore after deducting the portion of his profit. Importantly, under the remarket agreement, IBM India does not own any right, title, or interest or copyright and other intellectual property owned by the IBM Singapore. So IBM India says that I don't own anything here. I'm just like a distributor. Further argument was that he argued that computer software that is imported and for onward sale from the Singapore constitute goods, and this was directly covered under by the Supreme Court judgment in the Tata Consultancy case. We know that Tata Consultancy case was a famous case by the Supreme Court in which it was held that copyrighted articles are goods and not and not subject to copyrighted articles are goods here, and it was not subject to service tax. It was there earlier. It was argued that the impugned judgment that was the against IBM does not consider the royalty as per the DTA. And further it relied upon the Ajati Bacha Andolan and agreed that as per the section 90 subsection 2, the DTA should prevail over the domestic law, and if that prevails over the domestic law, it is the section 195 that should apply. Further, it was argued that the definition of royalty did not extend to the derivative product of the copyright, for example, book, music, CD, or the blah blah. So there is a copyright and there is a derivative of the copyright here. So these products, these argument was that these products are the derivative of the copyright, not the copyright per se. So therefore, he said that it is not a software. After that, he argues that there was a provision in the Copyright Act, and this provision, it was argued that there was a difference between the copyright in the original work and copyrighted articles, and that it was recognized in the 14B. So 14B, 14A and 14B is the important sections. We will go what is copyright as per the 14A and 14B of the Copyright Act. 14B especially deals with the computer program, which refers to the computer program per se and the copy of the computer program. So computer program and the copy of the computer program are two distinct subject matter. It says that there is a difference between computer program and the copy of the computer program. It further emphasized that the remarket agreement, no copyright has been given by the IBM Singapore. So IBM says that no, I have not given any right because I don't have any right here. Even the end user of India only receives a limited license to use the product by itself. So whatever the right to that, whatever the right he has got, he has only got the right to use and no right to sublicense, lease, or make copies. The license to use such shrink-wrapped computer software thus incidental and essential to effectuate the use of the product. So when we are downloading a software, it is for the purpose of use of the software, nothing else. It was further argued that okay, the principle of first sale, principle of exhaustion was cemented in the 14B2. So we will discuss what is the principle of first sales, doctrine of first sales, and the principle of exhaustion in this case. And it says that it has already been applied, it is already cemented in the 14B2 because there was an amendment in the 14B2, and that is the Copyright Act. And this amendment was with effect from 15 January 2002. First, there was an amendment in 1999, and after that, there was an amendment in 2000. We will see that part here. OECD, he also relied on the OECD commentary, which distinguishes the sales of the copyrighted articles and copyright itself. He further argued that importer IBM India is only a distributor and had no right to use the computer software, merely purchased a sealed shrink-wrapped soft product and resold it. These are the argument by Sri Dattar, Arvind Dattar. Second argument is from the Percy Pardiwala. Percy Pardiwala has supplemented the argument of the Dattar. Third argument is from the S. Ganesh, renowned advocate. He was a chartered accountant and advocate. Says that learned senior advocate appearing on behalf of Sonata Information has submitted that to comprehend the nature of the license, how to understand license, one should have to refer to 52 of the Indian Easement Act. Further, he also states that there were 3 cases from the AR. That was the Dassault system case that was reported in 322 ITR 125. GeoQuest. These 2 cases where it was favor of the SSE and the department has not filed any appeal against the SSE. So this odd position which was taken in the AR, that should be considered as a final, and therefore department should not contest this part, because department has not contested the earlier 2 judgment of the AR. But after that we will see that there was another judgment is there, Citrix judgment, which was against the SSE, and the SSE has come to the Supreme Court here. Now it is Ajay Bohra turn. Ajay Bohra, what Ajay Bohra argues here. On behalf of the Sasken Communication, he said that India USTT echoed the submission of the predecessor. In addition, he argued that the retrospective amendment of the 916, so he talks about the retrospective amendment, explanation 4, could not be applied to the assessment year because this case is assessment year 2001, 2002, 2001 and 2002, for which we are concerned, and it is prior to 2012, and that the law cannot be compelled to one to do impossible. This means when the amendment itself has come from the 2012, how you can ask me to deduct the TDS from the 2001? Another argument with another advocate, Pritish Kapoor, appearing on behalf of Sunday Computers, stress upon the language of the 14B2 of the Copyright Act. So 14B2 of the Copyright is important. Both pre and post 99 amendment brought to the effect from the 15th January 2000 and cited the doctrine of first sale, principle of exhaustion, arguing that the amendment after deleting the word regardless, ये पहले का language था, उसके बाद वो delete हो गया था. So we will go into that part, how it was deleted, what was the meaning of that. Another advocate, that was Sanchit Jolly, he was arguing on behalf of the engine analysis, जिसके लिए we are doing, and G technology, also echoed the submission. The Kunal Verma, who was arguing on behalf of Infinite Technology, argued that in case that fact of the case and payment made by the SSE were in the nature of reimbursement of the cost under the cost sharing agreement with German supplier of the software, and thus some chargeable under the provision of the Act has been paid attributing the 195 of the Income Tax Act. He, to buttress his submission, he relies on the AP Moller case here. That was the Supreme Court says that in the case of the reimbursement of the expenses, that is not an income which has been bidded under the sum, and therefore the 195 dues does not apply. So we have to see that what was the AP Moller case here. Revenue argument. What are the revenue argument says? Revenue argues that, appearing on the argues that, he argues that on the issue of the Income Tax Act, Copyright Act, and India USDTA and the EULA, that is the individual license agreement. He argues that the explanation 2.5. So this question, this issue is only the explanation 2.5 or explanation 2 subclause 5 of the 916. 916 explanation 2 defines the term royalty, and the explanation 5 is that we have to go through the clause 5, an income tax of the Income Tax Act, and applied the payment to the non-resident by way of royalty for the use or right to use any copyright. For this purpose, he relied on the language of the explanation 2.5 and states the word in respect of, because the term in respect of has come into that part. What is the meaning of the term in respect of? have to be given the wide meaning. He says that it has to be given the wide meaning. He then relied upon the CVT circular number 152, 27/11/1974. Therefore, the finance minister finance minister speech before the Lok Sabha on 7th of September 1999, and another CVT notification 21/2012 dated 13/6/2012, and he submits the explanation for how the explanation 4 of the 916 each of the act is clarificatory, and therefore this explanation should apply with effect from first
सर आपकी वॉइस ब्रेक हो रही है फिर से.
for this purpose for this purpose he relies on the section 195. He says that the assessment section and the TDS section both are different, and it should have been the TDS should have been deducted. He also relied the Article 30 of the India-USA Treaty about the rate in when the treaty was in force. Another argument is that when it was clear to make the deduction make deduction under section 195 of the Income Tax Act, so DTA will not apply at the time of the 195. Another argument is that there is a difference between the term SSC and payer as per section 27, and both are distinct here. The department relies on the Pilcom case. As I mentioned, that the Pilcom case was on the 194E, saying that the TDS should have been applied, even though let the SSC should claim the refund if they have the refund. If their income is exempt, let the SSC should claim the refund. But at the time of TDS, the TDS should have been applied, divorce the provision of the DTA. However, the Supreme Court says that Pilcom case cannot be applied because the Pilcom case was on the 194E, read with 115 BBA. Here, this case will fall under the 195, which refers to the rate in force, because 155 says the rate in force, And when we say the rate in force, that is coming under the section 2 subclause 37A. Section 2 subclause 37A makes us and essentially states that the rate of the 195, the DTA has to Supreme Court. Further, he relies on the Citrix case. The revenue relies on the Citrix case. I would like to before going to the Citrix case, I would like to state that there was a few cases from the Authority of Advanced Ruling. The first case was Dassault System case here. In the case of Dassault System, this case was in favor of the SSC. The AR, Authority of Advanced Ruling, has held that by having a computer software, the Indian person does not purchase any license or does not have any license, so it is not covered under the 916. So first case was Dassault case. Dassault case was in favor of the SSC. Department has not challenged the Dassault case. After that, it was Geocast case. Geocast case was also in favor of the SSC. It was not challenged by the revenue. Third case, that is the Citrix case, was there. That Citrix case, the AR took the U-turn. Why I will take the U-turn? The AR says no. The earlier judgment of the Dassault case will not apply in this case, and Dassault case and the Geocast was not apply, and therefore the Citrix case was against the SSC. And here in the Supreme Court, the Revenue Council is relying on the Citrus case. He is heavily relying on the Citrus case. He finally concludes that Tata consultancy case, which was on the service tax and sale tax, will not apply to the income tax provision. So the Tata consultancy case is not relevant here. With this framework, we have understood that argument which has been placed by both the SSC and the revenue, and now we are onto the discussion of the court, what the court has discussed here. The court has discussed the relevant provision of the Income Tax Act directly concerned with the section 2 subclause 7, that is the SSC, 37A rate in force, 4 charge of Income Tax Act, 5 section 5, that is the scope of the total income, 9 income deemed to accrue or rise in India, 90 the India power to enter into the DTA, section 195 TDS and other sums, 201 default in the TDS, 194 is that when you are paying to the for the purpose of a sports person, one day special section. Relevant provision of the Copyright Act. What was the relevant provision? Section 2 FA, that was the commercial rental. Section 2 FA, 2 FB, 2 FC computer program, that was there. 2M, that is infringing copy. 2O, later literary work. Section 14, that is the most important term that we'll be discussing. The 14, what is the copyright meaning on the copyright? No copyright escape as provided. Section 16 we will discuss. Section 18, assignment. Copyright, how the license will be given by the right of the owner against the person that. These are the Copyright Act that we discussed here. Now, after the analysis of the Copyright Act, Supreme Court has discussed a lot of copyright. And what is the analysis of the copyright? What is, let's see. And I'm reading the, under section 2 of the Copyright Act, literary work includes the computer program. First point is that the literary work, because when we see the section 916, in the explanation 2, there is no word called computer program. But in the explanation 3 and explanation 4, there is a word called computer program. So we will find out where the term computer program is there. So we'll find out the computer program is a literary work here. So computer program is coming out of the literary work. Therefore, section explanation 2, clause 5 below.
प्रकाश सर आपकी वॉइस नहीं आ रही है. सर ये वाली स्लाइड आप एक बार स्टार्टिंग से रिपीट कर देंगे प्लीज, थोड़ा वॉइस का इशू आ गया था.
कोई बात नहीं मैम, मैं जरूर रिपीट करता हूँ मैम. So the first discussion was on the Copyright Act. Copyright and section 2 was discussed. 2O of the Copyright Act that says the literary work includes the computer programs, and computer programs has been defined under section 2 FFC of the Copyright Act to mean that set of instruction expressed in the words outside the scheme in or for the other or in any other form capable of causing a computer to perform a particular task or achieve the particular result. Importantly, no computer right exists, or no copyright exists in India outside the provision of the Copyright Act and any other special law for the time being force white section 16. So section 16 provides how the copyright should be in India. So there cannot be any copyright deholds the section 16. Now come to the section 14, and section 14 is most important because a lot of discussion is based on the copy for section 14. and how the 14 is there. And I'm reading this 14. Though the an exclusive right. That is an exclusive right.
अशोक जी, आप कुछ आपकी कोई क्वेरी है? आपका हैंड रेज है अभी। अशोक जी।
हेलो।
हाँ अशोक जी, आपकी कोई क्वेरी है
नहीं
क्या?
नहीं
आपका
नहीं,
हैंड
क्वेरी नहीं था मैडम। मैं वो जो आपने बोला ना वही बोलना चाह रहा था। बीच बीच में जब आवाज नहीं आती है ना तो रिपीट करने को थोड़ा रिक्वेस्ट कीजिए बस।
हाँ
नहीं
हाँ
तो लिंक नहीं रह रहा है।
हाँ श्योर। आज थोड़ा सा टेक्निकल वो आ रहा है, प्रॉब्लम आ रहा है थोड़ा सा।
या आई अंडरस्टैंड। तो उनको खाली आपने जैसा एक बार बोला रिपीट करने को बोलिए।
श्योर सर, श्योर।
या प्लीज। अभी भी नहीं है ना आवाज?
नहीं, अभी सर ज्वाइन कर रहे हैं अभी।
ओके ओके।
हाँ, अभी बस थोड़ा मेजर इशू आ गया है नेटवर्क में उनके, तो प्रकाश सर विल बी रीजॉइनिंग अस इन फ्यू मिनट्स, तो लेट्स वेट फॉर हिम.
Sorry, am I audible?
Yes, sir.
I'm extremely sorry because of the poor connection. I'm facing the problem, but now I have changed my place.
Yeah,
Now I have changed my place here, and I expect that. Please make me attendee here so that I can start here.
Okay.
फिर चला गया अपना.
It will be rejoining. He said ना कि उनका
आ गया
attendee करने के लिए.
कर दिया, पहले से दिया.
Madam, please make me host here so that I can share my PPT.
कर दिया सर, कर दिया.
कर दिया सर.
Hello.
प्रकाश जी हो गया, आप कर दिए.
You can try, sir, sharing screen.
Yes. Now I will start here. I was discussing the para 2 that says that what is the copyright and what was the copyright in terms of the section 14(2) that was there and how the copyright is there. And how the copyright is discussed when the owner of a copyright of a literary work assigned work wholly or in part, then all the rights contained in the 14A and 14B has been transferred or has to be imparted. That is, the work for the consideration that can be transferred here. I'm not going to detail because of the lack of time. Now, after reading of the aforesaid distribution agreement, now we are coming for the EULA. What is the individual license agreement? After reading we know that whenever a person downloads a software, there is a individual license agreement that has to be downloaded. And whenever we download the individual license agreement, there is a condition on the individual license, and therefore it says what are the terms and conditions of the individual license. A reading of the aforesaid distribution agreement would show that what has been granted to the distributor is only a non-exclusive, non-transferable license to sell the computer software. So whenever we go through the individual license, we will find that what has been transferred is the non-exclusive license. It is a non-transfer license to sell the computer software. It's being expressly stipulated that no copyright in the computer program is transferred either to the distributor or to the ultimate end user. So by way of individual agreement, we will find that there is no copyright has been transferred. It is what has been transferred. It is a non-exclusive, non-transferable license to say that it is a right to, and it is the right to use only. That is and amplified by when it comes to the individual who has directly sold the computer program, then such individual can only use it by installing it in the computer hardware owned by the individual and cannot be in any manner reproduce the same for the sale or transfer, contrary to the terms imposed by the EULA. So it says that it cannot be used for that purpose here. So therefore, what is the difference between the term license under the EULA and the term license, a copyright license under the section 30? It says that in all these cases, the license that is granted under the individual license agreement is not a license in terms of section 30 of the Copyright Act, which transfer an interest in all or any of the right contained in the 14A and 14B of the Copyright Act, but is a license which imposes restriction or condition on the use of the computer software. Thus, it cannot be said that any of the EULA that we are concerned, which referable to the section 30 of the Copyright Act. It is most important to understand that EULA, that is the individual license agreement, is not a license in terms of the section 30 of the Copyright Act. And therefore, when we say that it has been entered into the EULA, that no license has been given of the Copyright Act. And since though no license has been given under the section 30 of the Copyright Act, no copyright under the section 14 has been transferred, or and there is no partition of the rights copyright under the 14A and 14B, and therefore it will not be covered under the Copyright Act. So we have seen the difference between the Copyright Act and the individual license agreement. With this, we will go to the Income Tax Act and we will find out, and here we have concluded that the license which has been given under the individual license agreement is not a license under the section 30 of the Copyright Act, and therefore it cannot be said that the license has been given. Now we go to the another part here. Now we will see that what is the DTA and how the DTA has to. So this judgment clarifies that, and circular number 728, that the tax reduction must take into account consideration and effect of a DTA provision should be given. The crucial link So first we'll understand the word term, what is royalty, which defines under royalty, and it does not, and it does so stating that definition exhaustive. It uses the expression meaning, the why the expression means. Second, the term royalty refers to the payment of any kind that are received by as a consideration for the use or the right to use any copyright in a literary work that is there. It also talks about the consideration. It talks about the all or any right, and it especially includes the granting of license in respect thereof. It states that transfer must be in respect of any copyright and literary work. So we will go to the next part here, royalty under the Income Tax Act. The term royalty, the term that is a transfer of all or any right, including the granting of license in respect of any copyright in the context of computer software, is referable to the 14A and 14B of the Section 30 and Section 30 of the Copyright Act. It is the most important finding. Till now, we have observed that there is a difference between the concluded that under the EULA, what the license has been given is a very restricted right, and it is right to use only, and therefore it is not a license under Section 30. Then it is a difference between EULA and Copyright Act. But what about the Section Income Tax Act? Here the Supreme Court says that the term all or any right, including the granting of license in respect of any right in the context of computer software, is referable to the 14A and 14B and Section 30 of the Copyright Act. This is a very conclusive part, that what is Section 916 talks about the right or the copyright, and this copyright talks about the Copyright Act, which is 14A and 14B and Section 30. Since Section 30 does not apply to the EULA, so therefore in this transition, Section 30 has not been applied, and therefore it is not covered under the Copyright Act, and therefore it is not covered under the 916. As has been held here in above, the expression in respect of or in respect of is equivalent to the word in or attributable to. Thus, the explanation 2.5 of Section 916 of the Income Tax Act, when it speaks the all or any right in respect of copyright, is certainly more exhaustive than the DTA provision, which speaks that the use of right to use any copyright. And this was recognized by the Delhi High Court in the case of DCM case. Now I will come to what is the observation of the Supreme Court. It said that whenever it comes to the expression use or right to use, which is under the 916, the same position would obtain under the expansion 2.5 of the 916. Yes, in as much as there must be under the license granted or sale made by the transfer of any of the right contained in 14A and 14B of the Copyright Act. So Section 916 refer to the 14A and 14B of the Copyright Act for the expansion 2.5 to apply. To the extent there is no difference in the position between the definition of royalty and royalty in the DTA and the definition of royalty in the expression 2.5 of the 915 of the DTA. Even if we were to consider the ambit of royalty only under the Income Tax Act, we will say that. So therefore, in this case, if we go to the 915 or 916 explanation 5, explanation 2 subclause 5, it is referable to the Copyright Act. Since it is referable to the Copyright Act, there is a difference between the Copyright Act and EULA. It will not apply to the case given here. Similarly, in the case of the DTA also, the terminology is the same. So therefore, is also not going to apply. Now the Supreme Court considered in a situation where there is no DTA, what will happen? Even if the Supreme Court says that even if we were to consider the ambit of royalty only under the Income Tax Act, on the footing that none of the DTA applies on the fact of this case, the definition of royalty that is contained in expansion 2 of Section 916 of the Income Tax Act would make it clear that there has to be transfer all of any right, which included the grant of license in respect of copyright in the literary work. So when the Act itself, when the Income Tax Act itself says that it is referable to the Copyright Act, but in this case, the copyright license has been given under the EULA, not under Copyright Act. So therefore, even if there is no DTA, the position is not going to change. So the Supreme Court say the expression including the granting of license in clause 2.5 of the Copyright Act to Section 916 of the Income Tax would necessarily mean the license to which transfer is made an interest in rights in respect of copyright, namely when there is a parting of with interest in any right mentioned in the 14A or 14B of the copyright, to the extent there will be no difference between the DTA situation and non-DTA situation. Now, so based on this one, we have understood till now that the Section 916 will be referable to the Copyright Act. When it will be referable to the Copyright Act, it refers to the Section 30 of the Copyright Act, and further, the EULA on which the license has been given is different than the Section 30 of the Copyright Act. And so therefore, Section 916 will not apply into this case here. Now, the Supreme Court is on the issue whether the explanation 4 that is there, whether it is a clarificatory. If it is a clarificatory, whether it will apply prospectively or whether it will apply retrospectively. Because the Revenue Council has heavily relied on the prospectiveness, on the retrospective application of the explanation 4 of the 916. So let's see what the Supreme Court says here. It is equally difficult to accept the learned Additional Solicitor General, that is the ASG, submission that explanation 4 of the Section 916 of the income tax is clarificatory. Say that no, it is not a clarificatory, as is always stood since 1/16/1976, for which he strongly relied upon the CBT Circular 150, Circular number 152, dated 27/11/1974. Says that no, it is not a clarificatory. Why it is not a clarificatory? The Supreme Court says because such a circular cannot apply as it would then be explanatory to the position that existed even before 916 was actually inserted in the Finance Act, while the Finance Act 1970.
सर वॉइस नहीं आ रही आपकी.
अब आ रही है मैम?
Yes, sir. Perfect.
So the Supreme Court says first line, it says that the circular number 150, circular number that was the 150.
सर अगेन वॉइस ब्रेक हो गई आपकी.
Supreme Court says that there cannot be this is because the Section 2 of the Copyright Act or the computer software introduced first time in the literary work, and it came in the 1994. So therefore, it cannot be a clarificatory one. Further, Supreme Court says that explanation 3, which was the first time that came with the term computer software, that came in 1991 and in 2000, in 1991, and after that there was an amendment in 2000. So what the Supreme Court says, let's see how the Supreme Court talks about. Furthermore, it is equally judicious for the aforesaid amendment, which was also inserted in explanation 6 to the 916 of the Income Tax Act, to apply with effect from 1/6/1976, when technology related to the transmission of satellite, optic fiber, or other similar technology was only regulated by the Parliament for the first time through the Cable Television Network Act 1995, much after 1976. So the point that the Supreme Court says, when the Cable Television Network Act came in 1995, the term cable television or network first time came into the 1995. How the Income Tax Act says that since it is up, the law will apply since 1990. Clear that the expansion 4 of the 916 of the Copyright Act is not a clarificatory. It says that it is not a clarificatory, the position as on 1/6/1976, but in fact expands the position and includes what is stated therein by the Finance Act 2012. So the first point that it says, that Supreme Court says that the expansion 4 is not a clarificatory amendment. It will apply prospectively. It will Finance Act 2012, and therefore this expansion 4 will not apply. And we have also seen that 916 will not be covered the license which has been given under the EULA. The DTA will not cover the license which has been given under the EULA. So therefore 916 is not going to apply. 919 DTA is not going to apply. And further also this another conclusion comes that the expansion 4 is not a clarificatory will, but it will apply prospectively. Second point is that the department argues that when even if the law was there since 2012, the SSC should have directed the TDS. The Supreme Court says no, it cannot be done because of the maximum. What is the maximum impossibility of performance? If there is impossibility of performance, how the TDS can be directed in 2001 when there was no law for the purpose of the expansion 4 at the time here. So the Supreme Court says it is thus clear that the person mentioned in the 195 of the Income Tax Act cannot be expected to do the impossible. It cannot be doing some impossible to apply the expanded definition of the royalty inserted by its expansion 4 of 916 of the Income Tax Act for the assessment in question at the time when such explanation was actually and factually was not in the statute. So therefore, it says that it cannot have been applied. Now it says about the cases of the AR. What are the cases that we have to consider for the AR? We know that we have discussed 3 cases here. Default cases that was in favor of the SSC, geocached system case that was in favor of the SSC, but AR suddenly took the U-turn, and it was the Citrix case in which the AR held that they are not going to allow this. They held against the SSC, and they held that such license under the EULA will fall under the 916. That is a license under the 916, and therefore they applied the 916. Supreme Court says that Citrix system case was not a good case here, and how the Supreme Court has discussed this Citrix case. Let's see what the Supreme Court says. First, before that, let you understand what is the Citrix case. The AR has given the region. What the AR has given the region, it is in bold here. The AR then region that the fact of that a license has been granted would be sufficient to conclude that there was a transfer of copyright and there was no justification for the use of the doctrine noscitur associs not to confine the transfer by way of license to What is copyrighted articles? It is nothing but an article which incorporates the copyright of the owner. It says that it is nothing but it is the copyright which incorporates the copyright of the owner, the exclusive license or the licensee. So when a copyrighted article is permitted or licensed to be used for a fee, the permission involves not only the physical or electronic manifestation of a program, but also the use or right to use the copyrighted embedded therein. This apart, the Copyright Act or the Income Tax Act or the DTAC does not use the expression copyrighted articles, which could have been used if the intention was to be claimed by the applicant. In this circumstances, the distinction appears to be illusory. So with this, AR says that the earlier judgment in the case of Dassault case, and that was the geo case here, is not going to apply in this case. And so therefore, AR takes the U-turn. What the Supreme Court says on the basis of the Citrix. Supreme Court says that ruling of the AR flies on the face of the certain principle. It says that AR has not followed the certain principle. What are the principles? When under a non-exclusive license, an individual gets the right to use the computer software in the form of a CD, the individual gets only receive the right to use. It is not an exclusive right. It is only a restrictive rights, and that is the right to use the software and nothing more. The individual does not get any right that the owner continues to retain under 14B of the Copyright Act. So there is no separation of right, there is no impartation of the right and the subsection 1 to 6 thereof. Thus, the conclusion that when the computer software is licensed for the use under the EULA, which is also a license in the right of use, the copyright embodied therein is wholly incorrect. Supreme Court says that it is wholly. The license for the use of a product under the EULA cannot be construed as a license spoken to by Section 30 of the Copyright Act, and in such EULA only imposes restrictive condition upon the end user and does not impart any interest relatable to any right mentioned in 14A or the 14B. So say that how the citrix was totally wrong, how the citrix was totally placed here. Further, in the case of citrix, there was one important point that has not been considered, and that point was coming from the book of the Coppinger and Kone James in the copyright, which makes it clear that the ownership of copyright in a work is different from the ownership of the physical material in which the copyrighted work may happen to be embedded. This important passage, curtly relied upon by the AR in Dassault case, was totally missed in the case of the citrix here. Further, the Supreme Court has concluded the citrix case is a bad law. I'm coming to the now come to the judgment of the judgment that is coming from the Karnataka High Court, and it is a Samsung case here. Supreme Court says that Samsung case and the citrix case has suffered the same fundamental error. They have not considered the Copyright Act in totality. They have confused between the right license under the EULA with the Copyright Act, with the license under the Copyright Act. Let's see what the Supreme Court says. The reasoning of the judgment also does not commend itself to us. The same error as was made by the AR in citrix case was made in this judgment. That is, no distinction was made between the computer software that was sold licensed on a CD or physical medium and parting the copyright with respect to any of the right or interest or right in the right mentioned in the 14A and 14B of the Computer or the Copyright Act. That being the case, the reasoning of this judgment suffers from some fundamental defect that ruling of the citrix case suffers from. By no such stretch imagination, the payment of such copyright computer software amounts to a royalty within the meaning of Article 12 or the Section 916 of the Income Tax Act. Supreme Court gives a conclusive definition, a conclusive finding, but says that by no imagination that copyright can be covered as the copyright under the Section 30 of the Copyright Act, and therefore Section 916 or the DTA both will not apply. Supreme Court in the Synopsis International case. Supreme Synopsis case that is coming from the Karnataka High Court, and let's see Karnataka High Court, what the Karnataka High Court has done the mistake and how the Supreme Court had distinguished these mistakes here. And very clearly Supreme Court says how the Karnataka High Court has not captured the right law in the synopsis. The reasoning of the High Court of Karnataka in the Synopsis Limited does not commend itself. First, what the reason? The state of Madras in the Swasti, that the term in respect of is only synonymous with the word on or attributable to. So the term expression, the term in respect of that is coming under the 916 916 explanation 2 clause 5 that say that in respect of, the meaning of the term in respect of has been discussed in the famous case of the state of Madras versus Swastik Tobacco, and he say that term in respect of means on or attributable to. There cannot be a wider meaning of the term in respect of. Such meaning accords with the meaning to be given the expression in respect of contained in the expression 2.5 of Section 916 of the Income Tax Act, and would not be in any manner make the expression otiose as was wrongly held by the High Court of Karnataka. So first of all, the word in respect of has to be given the right meaning. It should not be expanded meaning. Second, Section 16 of the Copyright Act, we say that how the copyright will be applied. Section 16 of the Copyright, we state that no person shall be entitled to a copyright otherwise than in terms of Section 16. Under this, the said is no person shall be entitled to copyright otherwise than under any in accordance with the provision of this act or other law for the time being in force has been completely missed by the Karnataka High Court. How it has been missed, making it clear that the expression copyright has to be understood in terms of Section 14 of the Act and not otherwise. So only 14 will define the Copyright Act. When it comes to the computer program, the High Court of India was wholly incorrect in stating that the storage of the computer program would be infringement of the copyright. So it was a totally incorrect finding of the High Court. Fourth, the High Court is not correctly referring the 916 of the Income Tax Act after considering it in the matter that has been applying that to interpret the provision under the convention between the India and the Ireland for the avoidance of DTA. Article 12 of the aforesaid article treaty defining the royalty would alone be relevant to determine the taxable under the DTA. It is more beneficial to the SSC as compared to the 916 of the Income Tax Act as compared to the High Court. Thus again, the 90 subsection 2 of the Income Tax read with section 4 that has not been properly appreciated. Section 90 subsection 2 expansion 4 says that the Section 90 subsection 2 says the beneficial provision has to be applied so here the Karnataka High Court has missed in applying the beneficial provision. So therefore it says that this case was not a good case here. Fifth point was that the copyright article was sold. When a copyright article is sold and the user gets a right to use the intellectual property right embodied in the copyright, which would therefore amount to transfer of exclusive right to the copyright owner of the work, it is also wholly incorrect. For this reason, the judgment of the High Court in Karnataka, the High Court of Karnataka in the synopsis case, not a good law, and therefore it was set aside by the Supreme Court. Now come to the cases from the Delhi High Court. Delhi High Court was cases from here the software was embedded on the hardware. First case was Ericsson case, was in favor of the SSE. Nokia case was there in favor of the SSE. Infrasoft case, that is the most important case, and it was in favor of the SSE. The revenue has argued the Samsung Electronic case in this case, but the Delhi High Court has disagreed here. So it's the first time in the Infrasoft case that the Karnataka High Court judgment of the Samsung was argued by the revenue, but Delhi High Court has not accepted this one. Motorola case was there. The Delhi IT has not accepted the argument of the Citrix case. JT Corporation, that is the most important case, 392 ITR 80, that was in favor of the SSE. So Delhi High Court was in favor of the SSE. Karnataka High Court was against the SSE. Authority of Advance Ruling, 2 judgment was in favor of the SSE. Last judgment was against the SSE. So that was under the challenge here. So what was the principle that was laid down in the JTE? And it is the same principle is the conclusion of the case. Let's see, because it is the heart of the judgment here. The conclusion that can be derived on the reading of the aforesaid judgment are as follows. It says copyright is an exclusive right. First, the copyright is an exclusive right, which is negative in nature, being the right to restrict other from doing certain act. So first of all, we should understand the copyright is an exclusive right, which is negative in nature, being the right to restrict other from doing certain acts. Second point is that copyright is an intangible, incorporeal right in the nature of the privilege, which is quite independent of any material substance. Ownership of copyright in a work is different from the ownership of physical material in which the copyright work may happen to be embodied. An obvious example is of the purchaser of the book or the CD, DVD, who hopes to be the owner of the physical article, but does not become the owner of the copyright inherent to the work. Such copyright remaining exclusive with the owner here, remain exclusive with the owner here. Third part, parting with the copyright entails the parting with the right to do any of the act mentioned in the section 14 of the Copyright Act. So whenever we'll say that some copyright has been transferred, we have to see that what are the right was there in the section 14, whether that right has been transferred or whether that right has been assigned. If that right has been assigned, then it will come under section 13. If that right has not been assigned, then it will not come under the section. The transfer of material substance does not in itself serve to transfer the copyright therein. The transfer of the ownership of the physical substance in which the copyright subsists gives the purchaser the right to do with the whatever he pleases, a right to reproduce the same and issue it to the public unless these such copies are already in circulation and the other act mentioned in section 14 of the Copyright Act. Fourth point that it says, a license from the copyright owner conferring no proprietary interest on the licensee does not entail parting of any copyright and is different from the license issued under the section 30 of the Copyright Act, which is the license which grant the license to the license and interest in the right mentioned in section 14A and 14B of the Copyright Act. Where the core of the transaction is to authorize the end user to have access to the make use of the licensed computer software product owner, which the SSC has no exclusive right, no copyright is parted with, and consequently no infringement takes place, as is recognized by the 52A of the Copyright Act. It makes no difference whether the end user is enabled to use the computer software that is customized to its specific or otherwise. A non-exclusive, a non-exclusive, non-transferable license merely enables the use of the copyrighted product is in the nature of the restrictive condition which is ancillary to such use and cannot be constituted to a license to enjoy all or any of the enumerated right mentioned in section 14 of the Copyright Act, and it is not a license under section 30. The right to reproduce and right to use are different. Computers are distinct and separable right, as has been recognized by the SBI versus Collector of Customs case, and former amounting to party with the copyright and later extent of non-exclusive EULA not being doing so. With this, consequently, the Supreme Court says that Dassault was a good case, GeoCast was a good case, Ericsson was a good case, Nokia was a good case, Infrasoft was a good case, JTE was a good case, and therefore is approved all these cases. Supreme Court approved all these cases. Now come to the last part of the discussion. What is the interpretation of the treaty? It says that the treaty has to be liberally interpreted. How to understand the term treaty, and what is the treaty and what is the meaning of the term OECD community, how the OECD community how the government recognizes the OECD, how the court recognizes the OECD community. For this purpose, the Supreme Court say the OECD community has been recognized by the Indian courts in various judgments. First, foremost is the Ajati Bachao Andolan case. Formula 1 case, Supreme Court has recognized. CIT versus E-Fund case, Supreme Court has recognized and says that OECD community has a persuasive value. So what he talks about, just read this part. When the definition of royalty is seen in all the detail that we are concerned with, it is found to be that royalty is defined in the manner either identical or similar to the definition contained in Article 12 of the OECD Model Template. This being the case, OECD commentary on the provision of OECD convention then becomes relevant. The OECD community has been referred to and relied upon by the several earlier judgments. So Supreme Court says that OECD commentary is quite relevant. What is the meaning of the term reservation on the commentary? Reservation has no meaning unless it is an ambiguous and it has been brought to the text of the treaty. It says that whatever the reservation India has taken, that has no meaning unless it is unambiguous and it has been brought into the text of treaty. The Delhi High Court in the New Sky Satellite 382 ITR 114 has especially held that there is no meaning of the term reservation. Further, even though India has given the reservation, India has entered certain DTA or has amended certain DTA, but these reservation has not been converted into the text. Further, it says that High Power Committee report is not relevant. Circular number 10/2002 is also not relevant. With this, we are coming to the conclusion. What the conclusion has Supreme Court has taken. Given the definition of the royalty contained in Article 12 of the TTA, mentioned in the paragraph 14 of the judgment, it is clear that there is no obligation on the persons mentioned in section 195 of the Income Tax Act to deduct the tax at source, as the distribution agreement or the individual license agreement is in fact of these cases do not create any interest or right to the distribution or individual which could amount to the right or right of any copyright. The provision contained in Income Tax Act 916 along with expansion 2 and 4, which deals with the royalty not being more beneficial to the SSC, have no application on the fact of this case. It says that 916 has no application on this case. The answer to the question posed before us is that the amount paid by the resident Indian individual distribution to a non-resident computer software manufacturer supplier as consideration for the sale or consideration for the resale use of the computer software through the EULA distribution agreement is not the payment of royalty for the use of the copyright of the computer software, and the same does not give rise to the income tax payable in India. As a result, a person referable under 195 of the Income Tax Act is not liable to deduct the TDS. So Supreme Court gives a finding that no liability to deduct the TDS under the Income Tax Act. The answer to the question will apply to the four categories, all the four categories that we have discussed here. The appeal, therefore, the Supreme Court says the appeal from the impugned judgment of the High Court of Karnataka is allowed. Yes, since High Court of Karnataka was against the SSC, the Supreme Court has allowed that judgment, that order, that appeal. Aforesaid judgment is set aside. That Karnataka High Court judgment is set aside. Citrix judgment has been set aside. The appeal of the revenue against the Delhi High Court judgment is also dismissed. With this, I have come to the conclusion.
सर वॉइस चली गई थी कंक्लूजन के बाद.
Hello.
हाँ जी सर.
Am I audible, ma'am?
Yes sir, now audible. Conclusion के बाद voice आपकी break हो गई.
I'm just reading we have read to the conclusion that the conclusion is that the section 916 is not going to apply into this type of transaction because this transaction is governed by the individual license agreement. This transaction is not governed by the Copyright Act. So therefore 916 is not going to apply. The DTA will also not apply. The Article 4, the explanation 4 of that 916 is a clarificatory amendment. Is not a clarificatory amendment. So it will apply prospectively. It will apply after 2012. Further, there is no meaning of the term reservation here. Reservation is not going to help the revenue. Supreme Court has upheld the finding of the Delhi High Court in the Motorola case. You first start with the Nokia Ericsson case. After that, it is Nokia case. It was the Infrasoft case. Third was the Motorola case. Supreme Court has upheld all the Delhi High Court judgment, has set aside the judgment of the Karnataka High Court from the Samsung cases, and these cases also the Supreme Court has set aside the judgment of the Karnataka High Court, and the Supreme Court has also set aside the judgment of the Citrix case coming from the Authority of Advanced Ruling. Supreme Court finding is that in all these cases, that this transaction is not covered into the Copyright Act. So therefore, 916 cannot apply because the 916 is referable to the Copyright Act. With this, I have concluded my presentation on this case. If there is any issue that I can take it further, or otherwise I can go to the next case. I'm extremely sorry that due to the very frequent disturbance, I was not able to go smoothly here. But yes, I'm ready to take any question. I have done all the preparation, but due to certain network problem, I am unable here, man.
It's
Which
okay, sir. Sometimes it happens.
is beyond my control.
Yes, which is not in our control, but we appreciate your patience and our audience patience also. They were still with us to attend the session, and I think we have 15-20 minutes more if we can discuss any other
So,
case. Prakash,
so,
sir.
so can I take some cases question? If there are any question, you can just ask them to take any questions here. Otherwise, I can move to the one.
Yeah. Right now, there is no question. But one thing which are you there, Prakash sir?
Ma'am?
I think, one thing which I want to clarify, this judgment will hold true up to 2012. I think some network issue is there. Yes, Prakash sir.
Am I audible, ma'am?
Yes, sir. Now audible.
Yes.
I just want to clarify myself whether this judgment will hold true up to that 2012.
No. This judgment will hold post 2012 also.
Okay. Like, in last conclusion, you said ki up to 2012. So that was some confusing point for me.
Hmm.
After 2012 also, same position will be there. No need, the same situation is.
Why this? Why I am telling that why the same position will apply?
Huh.
Because the license that we are getting for the computer software is through the EULA, that is the Individual License Agreement, not through the Copyright Act. Since we are not getting the license through the Copyright Act, Section 14 and Section 30 will not apply, or the copyright is not going to apply. And 916 always refer to the Copyright Act.
Okay.
It does not refer to the EULA. So therefore, it will always, even after 2012, will not apply here.
And to differentiate whether I'm getting any license through EULA or copyright, how can I differentiate?
Yes, yes. If you will get the license under the EULA, you will get a very restrictive right. Right, only right to use. Suppose that you have a mobile phone. In the mobile phone, there is a WhatsApp software that we are using here. We are using for the purpose of only to use the WhatsApp. We don't know what is the source code. We cannot copy the WhatsApp. We cannot change this WhatsApp software. We have no right. We have no right to reproduce this software.
Okay.
So therefore, since there is no right, the only right which has been given is only the using right here.
Okay.
That too on the specific mobile phone or on the specific system here. Suppose that if your friend wants to say that, okay, I want to use the WhatsApp. Can you transfer the WhatsApp software from your mobile phone to his mobile phone? The answer is no. You will ask him, you will go and download the WhatsApp.
Yes.
So you don't have any right here, only right to use. Whenever this right is used is restrictive right, therefore you are getting the license only from the EULA. And this license from the EULA is not a license under the Copyright Act. So there's a difference between the EULA right and there's a difference between the Copyright Act. 916 the license under the Copyright Act. It does not say license under the EULA here, because this license is a very restrictive license here.
Thank you. Jitendra sir, do we have time for a discussion of any other case?
Maybe 10 minutes, we have 10 minutes, we can do.
No, we have a very important case. If you wish, I can start on the important case also. And that is important case is on the trust.
Okay, sir. I think we can go ahead. We have 10-15 minutes. So.
Okay. Madam, ये तो
As you say, sir.
No, I will go. I will take up this one. Why I'm trying to say, it is though this is was the due to system problem or network problem. It has
Yes.
taken a lot of time. Otherwise, I have tried to cover 2 or 3 cases all more here. Now I will cover it, ma'am. I know that lot of person do the trust work of the trust. You must have the client. The trust is a client, but I'm on the understand. I am on the impression that lot of person are not aware of the trust law. Why I'm trying to say not aware of the trust law? Here, this is a case. Here, this is a case where a trust was there, and he has filed the return. Trust has filed the return as an AOP, and this trust has received around 5 crore rupees or to around 25 crore rupees from one of the settler. Therefore, and the department was of the contention. The trustee, who is the individual, has to be an individual, since he is representing the individual beneficiary, and since he is representing the individual section 56 to 10 has been applied to 7, sorry, in this case to 7 has been applied, saying that if a person has receives the any amount for which he does not provide any services, then this amount will be treated as an income from any other source, and the 56.2 had been applied. So please appreciate that a trust can also be covered under the 56 to 7 or 56 to 10. How it will be covered, we will see into this part here. This is the case where the revenue has filed appeal under 260A. And what is the case of the status of the, it is the status of the private discretionary trust. The first question is that what is the private discretionary trust? We have to understand that what is the trust. When we go for a trust, there are 2 types of trust. First is the trust is called public trust. Second is called private trust. Public trust, it can be discretionary trust, it can be non-discretionary trust. Private trust, it can also be a discretionary trust as well as non-discretionary trust. If it is discretionary trust, this means that trustee has the discretion to the trustee has the discretion. So who will file the return? The trustee will file the return. So it is a trustee will file the return. When the trustee will file the return, we have to see that how the trustee will file the return. But if it is a non-discretionary trust, then this means it is a pass-through trust. And when it is a pass-through trust, it is the beneficiary who is going to file the return. Most important case that we should understand here, because that is, so we have to understand. I have seen a lot of persons are filing the return of the trust and generally try to file the return as an AOP. First of all, please appreciate that trust is not a person under the Income Tax Act. We have to find out who is the trust is, whether the trust is a private trust or is a public trust. If it is a public trust, then it can go to the AOP or BOI. It is not further, it is not an AOP, it is BOI. It is not an association of the person, but it is a body of individual. So we can say that trust is a body of individual only. Second part will come. The second thing will come when the trustee, there is a trustee is there, or there is a one or more than one trustee is there. Each trustee will be assessed based on the who is the beneficiary. If the beneficiary is the individual, then the trustee will be also be individual. If the trustee is a partner, if the beneficiary is a company, then the trustee will also be a company. even though he himself is individual. So please appreciate that term here. And here the section 5627 has been applied. 5627 has been applied. And the question before the Supreme Court is that, first question is that, what is the status of the private discretionary trust? So what is whether it is covered under person under section 2 sub 31, section 160 or 161. Second is the applicability of the section 5627. When a trust is treated as an individual, can a trust be treated as an individual? The answer will find yes, a trust can be treated as an individual for the assessment purpose, only for the assessment purpose. What is the scope of section 144A? Whether we can challenge the 144A? We know that under 144A, it is the joint commissioner who gives the direction to the assessing officer on certain points here. So who can approach to the assessing officer? Is joint, who can approach to the joint commissioner? Yes, but the SSC can approach, the department at the AU can also be approached, or the joint commissioner suo motu can give a direction here. Whether the joint commissioner is required to give the opportunity to the SSC? Yes, there are certain cases here where the joint commissioner should give the opportunity to the SSC. We are facing this question in the practical cases here. Additional question raised before the respondent. Can the additional question raised by the respondent is the most important part. In this case, the respondent has not filed the appeal. So there was an order by the ITAT, the respondent, the ITAT, and it was in favor of the SSC. Since the SSC, it was in favor of the SSC. SSC didn't file the, even though some point he was agreed, but he didn't file the appeal. The revenue filed the appeal. When the revenue has filed the appeal, the SSC wanted to raise some question of law or the additional question. The department took the objection here and says that the SSC cannot raise any additional question. So therefore, there cannot be any question from the SSC side. SSC can only be the SSC can only be a respondent. But there are some contradictory view in this case here. Even if the SSC has not filed the appeal, or even if the SSC has not filed the cross appeal also, the issue arises, what will happen to the cross objection? What is the time of filing the cross objection? Cross objection filing is within 30 days. The respondent SSC is a private discretionary trust for the post-retirement benefit of the retired senior employee of the Searam Group of companies. Trust filed ITR for the assessment year 14-15 as an AOP. The trust 25 crore was received from the 6th company of the Searam Group, addition of the corpus. The trust has shown that it is an addition to the corpus fund. The trust has not transacted this transaction through the profit loss account. It has transacted the transaction directly to the balance sheet, saying that it is an addition to the corpus. 144A was invoked by the joint commissioner. That was the suo motu was invoked, and the opportunity was given. SSC status was considered as individual, and this corpus addition was covered under 224(4)A of the addition 4A, and the addition was made under 5627. So the first of all, what the joint commissioner has done, he has invoked the 144A. After that, he says that this SSC is not an AOP, but this SSC as an individual. Third says that the 25 crore rupees which SSC has received as an addition to the corpus fund, it is not in corpus fund, but it is an income from other sources, and it is covered under the 224(4)A of the Income Tax Act. And further, this income should be taxed at the 5627. CIT appeal confirmed the status of the SSC. First of all, now the order is passed, and CIT appeal has confirmed the order of the SSC. The status of the SSC. First, he confirmed the status of the SSC. For the CIT appeal, what he does, he transfers this income from 224, subsection 224A to 224.15. 15 says about the income which is covered under the 5627 and affirm the additions here. What the CIT appeal does here, what the CIT appeal says, referring to the section 161, it has been held that SSC being the representative SSC. So we have to understand the term, what is representative SSC. CIT being a representative SSC has to be taxed in the like manner and to the same extent as it would have been respect of the beneficiary. It says that the trustee, the trust is the SSC is the being representative SSC. It has to be taxed in the like manner and to the same extent as would have been in respect of beneficiary. And the status of the SSC is to be determined with reference to the status of the beneficiary only. And the beneficiary being the individual, the SSC status is to be of the individual. It is the first finding. The CIT approved the finding of the JCIT that the status of the trust is to determine from the status of the beneficiary by placing reliance on the decision of the case that the CIT versus CA head office cases, that was a 141 taxman. Further, CIT affirmed the finding of the JCIT refusing to treat the SSC an AOP. CIT says that SSC is not an AOP under section 231 of the Act and relies on the Morrison beneficiary case. And third part is that he confirms the addition here. So first is that CIT says that you are an individual. You are not an AOP. The SSC contains the term individual. Then the SSC says the term individual, which is incurring into the 5627, is different. What is it different? It says that the term individual always lives to a living person, whereas the area trust is not a living person. So it says that trust income under the 56, the individual occurring in the 5627 has to be treated as different. How the CIT appeal says that. The SSC contends that the term individual occurring in the 5627 has to be interpreted with reference to the context in which it has been used in the said provision. In the said word, he contended that the proviso, there is a reference to the relative of the individual, occasion like marriage, etc. Therefore, the term individual occurring in section 5627 shall mean only living person. It says that SSC argument is that the individual for the purpose of the 5627 should be only the living person. The issue deals with the scope of total income. This after that, the court has discussed the issue of the CIT. Court has discussed the issue by the CIT. Firstly, by noting the section 5.1 of the Act, which deals with the scope of total income, to include all income from whatever source derived, which is received or deemed to be received by India. It has held that the SSC, in the status of the independent SSC, mission. The CIT pointed out however, the CIT says that income will be not covered under the 224.4A, but it will cover under the 224.15, and therefore 5627 will. There's a lot of discussion on this part. SSC referred to the insertion of the clause 10 of the 56.210 and says that what is the meaning of the individual. SSC has argued a lot of points here. I'm coming to this part. What was the challenge before the High Court? 144A was challenged. ITT uphold the 144 if that was challenged. Issue of limited scrutiny versus full scrutiny was also raised. The tribunal confirmed the status of the SSC as an individual. However, tribunal didn't agree with the 224.15, 56.27. So tribunal has given part relief in this case. So whether the tribunal says that although you are SSC, you are individual for the purpose of assessment here, but the 56.27 cannot be applied on you. The Supreme, how the court considered, how the court has considered. So what is the Supreme ITAT briefing is this part? I'm coming to the directly on the High Court order. Status of the what the High Court before the agreement, the argument before the High Court, SSC argument is there. It is also the SSC argument. It is also the SSC argument. It is the revenue argument. I'm coming to the revenue argument. The term, what the revenue has been argued. Conclusion, what the High Court has come to a conclusion. High Court says that SSC having not filed an appeal as against the finding rendered by the tribunal on the issue of jurisdiction and the procedural aspect followed by the assessing officer, it cannot be stated to be an aggrieved person over such finding in the absence of appeal at their instance under the section 2 of section 260 of the Act. First point that High Court says define that SSC has no power to raise any grounds here because SSC has not filed an appeal. So therefore, as an advocate, as a chartered accountant, it is our duty, if we are aggrieved with any order, we must file the appeal. Unless and until the aggrieved person is before the court by way of appeal, the question calling upon the court to frame additional substantial question of law by invoking the power under section 268(4) of the Act does not arise. So therefore, the court says, I am not going to look into the matter of the 144A, which has since you have not appealed before against that order of the ITAT. After that, SSC says, what did the SSC says? What the court says? The SSC in the instant case or the SSC in the instant case or the trustee are only representative not known cannot be accepted.
सर वॉइस ब्रेक हो रही है आपकी.
हेलो
जी सर, वॉइस ब्रेक हो गई थी अभी.
अब आ रही है मैम?
हाँ सर, अभी आ रही है.
So what the High Court has stated that SSC in this instant case are trustee only on representative of the beneficiary, and the income is required to be taxed in the like manner as per section 161 and to the same extent as would be in respect of beneficiary. The argument that the beneficiary are not known cannot be accepted because the deed of trust as well as the supplemental deed would show that the beneficiary are the top level executive of the Serum Group of the company who will be extended financial benefit on attaining the age of 60 years on the set, and a set of person who would be benefited have also been mentioned in the annexures. It is to be further noted that the names of those persons who are 8 to attain 60 years are well within the knowledge of the SSC, and more particularly in the 6th group concerned, which extended the grant, and those beneficiaries are individual, and therefore the SSC in this instant case, having received the perquisite on behalf of the beneficiary, should be treated as the representative of those beneficiaries and therefore be taxed as an individual. Some has raised hand, ma'am.
Sir, one hand raise is there. मैं अलाउड टू टॉक करती हूँ, उनका नाम नहीं लिखा हुआ है.
कोई बात नहीं. Yes.
If you have any query, you can ask. Hello. Only phone number is there. I don't know who he is. He or she. I don't know.
You have already allowed the talking here.
Yes. I think maybe by mistake.
No issue.
Continue, sir.
I would like to conclude this part here. How the court has relied. The court has relied on the Aryan Trust case. It was held that even an artificial judicial person can be treated as an individual under section 194, and there is nothing to restrict the applicability of the word individual only to the natural person or the human being as it applies to the artificial judicial person also. The court said that even the artificial judicial person can be individual. There is no person. Then the the term association of person. Also, this could be no doubt that the beneficiaries who were named in the trust as recipient of the income of the trust could not be considered as an AOP. The decision of the Merchant Beneficiary Trust was relied in the case of the TSK Enterprises, wherein the SSC was assessed an individual, as well as the judgment of the division bench in the case of TCA case here. In Jogendranath Thakkar case, the Honorable Supreme Court has observed that there could be no reason why the word individual of Section 3 of the 1920 Act should be restricted to the only human being. It can extend to the juristic entity also. In WTO versus CK Muhammad Kai case, Supreme Court has held that individual could fall within the ambit of taxing provision. The said decision of the Honorable Supreme Court is referred in the Srimati Shodra Devi case. Thus, the term individual used in the Act does not mean only a human being. Most important finding is that, ma'am. Thus, the term individual used in the Act does not mean only the human being, but wide enough to include group of persons constituting a unit for the purpose of the Act. It was pointed out that reference to the wife, daughter, and child, an individual under Section 4 of the Wealth Tax Act would not lead to the construction of the expression individual in Section 3 of the said Act is referable only to a single human being. So that it says that individual does not mean only single human being, it can be a group of person also. What was held in Susa Saini Corey case, it was held that the joint trustee must be taken into a single unit in the law and not as AOP. The view was approved by the Honorable Supreme Court in the trustee of the Govardhan Das Govind Ram Family Trust. So it was held that the trustee cannot be taxed as an AOP because trustee, it should be treated as an individual. Why it is an individual? Because it is not an association of person. In CIT versus Salim District Urban Bank Limited, the question which failed for the consideration whether the cooperative central bank registered under the Indian Cooperative Society, whose shareholder consisted of the individual and cooperative society, was an individual for the purpose of Section 3 of the 1920 Act, while holding that to give the word individual the meaning of the person only would be to disregard the scheme of the Act and only to rob the word of the accepted meaning. What was happened in the case of Jagannath Naskar case, it was held by Supreme Court that the deity, even the deity, though a juristic person, is not a that would take the plural the court has concluded here. It is further submitted the SSC case, the beneficiary are the indeterminate, and the individual share of the income were also indeterminate, and the voluntary contribution were received by the SSC trust into their corpus and did not form the part of the income distributed to the beneficiary. This arrangement must necessarily fail for the reason given by us earlier, as we have held that the SSC is required to be assessed as an individual. The court says the SSC has to be assessed as an individual. The beneficiary have been identified, and the identifiable under Section 161 would also become the income of each, especially receivable on behalf of or on benefit of any person who is known and whose share are determinate. The factual position as brought by the JCIT and CITR clearly shows that the methodology adopted by the SSC was to circumvent the provision of the Act. With this, the finding is that the trust can be treated as an individual because it was for the purpose of the beneficiary of the individual. Even though there are a number of trustees, if there are an individual group of individuals, that can also be considered. Further, most important point was that if a trust, even if that individual is there, it can also be considered, even if a trust, the 56(2)(7) can be applied. With this, I am concluding my presentation, ma'am. Asa, ma'am.
जी सर. तो थैंक यू वेरी मच सर.
Yes.
काफी पेशेंस के साथ आपने दोनों केस लॉस को हमें एक्सप्लेन किया अच्छे से. बट हाँ, कुछ और भी हम कर लेते. आज थोड़ा सा नेटवर्क का डिस्टर्बेंस ज्यादा रहा, तो एक रिक्वेस्ट करेंगे सर, इफ पॉसिबल फॉर यू.
Yes.
अगर फ्यूचर में कभी टाइम निकल पाता है तो वी वुड लाइक टू डिस्कस दीज, स्पेशली द फर्स्ट वन केस अगेन.
No issue, ma'am. No issue. आप जितनी बार बोलिए उतनी बार हम डिस्कस करने को तैयार हैं.
एंड उतने दिनों में आई थिंक कि जो ऑडियंस है वो भी उस चीज को रीड कर चुके होंगे एक बार. तो होता है ना, एक बार सुना, 2 बार सुना, 3 बार, तो वो ज्यादा अच्छे समझ में आ जाता है. तो एक वो वाला बेनिफिट भी, अब जैसे मैंने आज सुना है तो मुझे लग रहा है हाँ कुछ चीजें पहले रीड कर लूंगी तो और अच्छा समझ में आ जाएगा मुझे. तो ये रिक्वेस्ट एक हमारी रहेगी आपसे. एंड सचिन सर आ चुके हैं, तो सचिन सर वेलकम.
थैंक यू मैम. इनफैक्ट मैं अभी नहीं आया, मैं बहुत पहले से, बट मैं यूट्यूब पे सुन रहा था सर को.
ओके.
तो सॉरी, ड्यू टू सम टेक्निकल रीजन आज थोड़ा इश्यूज रहा, बट एनीवे डेलिब्रेशन वाज एक्सीलेंट. कंटेंट वाज वेरी हेवी. आई थिंक प्रकाश सर का फिर से डिस्कनेक्ट हो गया शायद.
यस, आई थिंक सो. नेटवर्क इश्यूज आर टोटली बियॉन्ड आवर कंट्रोल. कुछ नहीं कर सकते इसमें.
हेलो.
हेलो.
Yes,
जो टॉपिक था वो जो केस आज पिकअप किया गया था वो बहुत ही एक्सीलेंट केस लॉ है, लेकिन कंटेंट इतना हेवी था, मुझे ऐसा लगता है कि पहले से ये मटेरियल शेयर करना चाहिए सभी पार्टिसिपेंट्स के साथ, कि पहले वो पढ़ लें और फिर उसको दोबारा डिस्कस किया जाए. मैं तो प्रकाश जी से रिक्वेस्ट करूंगा कि एक बार सर इसी सेशन को हम लोग रिपीट करेंगे इसी केस लॉ के साथ, और एक्सक्लूसिवली सिर्फ इसी केस लॉ के ऊपर डिस्कशन करेंगे.
यस, ये केस लॉ में अभी बहुत सारे प्रिंसिपल अभी डिस्कस करना बाकी है. In fact, there are a lot of principles which we need to discuss here. और कैसे कॉपीराइट को इंटरप्रेट किया जाता है, बिकॉज मुझे मालूम है कि हम लोग सभी चार्ट अकाउंटेंट लोग 195 में 15 CACB इशू करते होंगे. आप लोग सभी लोग करते होंगे सर्टिफिकेट 15 CACB इशू करते वक्त आपको सारे केस आता होगा कि वेदर ये रॉयल्टी है या नहीं है. आप लोग तो बोलते होंगे चलो टैक्स लगा दो, लेकिन आप अगर देखिए लॉ को कैसे डिस्कस किया जाए. इनफैक्ट आई वांटेड टू रेज दिस इशू इन अ डिफरेंट फोरम. And I would like to share also that NIRC has requested me to give his briefing on these cases here. I have to write for the NIRC on this case itself here. So I'm writing on this part here, and hopefully it will be published in this month itself here. I'm writing for them also. And for this purpose, I was trying to go in depth of that part. But I understand कि ये इस जजमेंट में काफी कुछ इन डेप्थ जाना चाहिए हम लोग को, और भी लोगों को इन डेप्थ में है. मैडम ये
डेप्थ में जाएंगे सब उतना क्लियरिटी आती है कि जो एंड यूजर राइट्स है और कॉपीराइट में बेसिकली फर्क क्या होता है, वो बहुत माइन्यूट फर्क है, लोगों को समझ नहीं आता है. हाँ,
बट होपफुली मैंने आज आप लोग को बहुत क्लियर किया है.
क्लियर किया आपने सर कि कॉपीराइट का मतलब कि इफ यू हैव राइट टू रिप्रोड्यूस तो वो कॉपीराइट है. अदरवाइज खाली आपको राइट टू यूज है तो इट इज एंड यूजर राइट.
यस, दैट इज द राइट, इंडिविजुअल राइट हियर.
तो वो बहुत स्ट्रेट फॉरवर्ड क्लियर लाइन है कि भाई सिल्वर लाइन है कि उसको पकड़ के चलेंगे तो हमें डाउट्स नहीं आएंगे उस चीज में
कभी भी. एंड कॉपीराइट एक्ट को बहुत अच्छी तरह से समझा जा सकता है.
बिल्कुल सर.
इनफैक्ट मुझे काफी लोगों ने रिक्वेस्ट किया कि सर आप इसको कवर कीजिए, तभी मैंने बोला कि नहीं, मैं इसको कवर करता हूं। ऑल्दो मेरा प्रेजेंटेशन उन चारों केसेस के ऊपर आई वाज रेडी, फिर भी मैं इसको टेकअप करने की कोशिश किया, बट आई वाज ट्राइंग टू कवर ऑल द 4 केसेस इंक्लूडिंग दिस ऑल्सो, बट ड्यू टू इंटरनेट प्रॉब्लम मैं प्रत्येक जगह जैसे बढ़ता था कुछ ना कुछ प्रॉब्लम हो जाती थी।
देखिए आपके साथ पेशेंस है, आपने उसी अपने मोमेंटो को बरकरार रखा इतनी ग्लिचेस आने के बाद भी।
आई थिंक फिर से थोड़ा सा ब्रेक हुआ है
टू डिस्कस दिस केस अगेन।
जितेंद्र सर।
आप वोट ऑफ
जितेंद्र जी।
थैंक दीजिए मैडम।
Yes, Asha ma'am, please, for vote of thanks.
For a formal vote of thanks. Okay. Thank you, Prakash sir, for again explaining us one more important case which has been recently pronounced by the Supreme Court, and बहुत डिटेल में आपने इसको हमें समझाया ठीक से, एंड जैसा हमने अभी रिक्वेस्ट की है एंड आपने रिक्वेस्ट हमारी मान भी ली है, थैंक यू सो मच कि आप हमें फिर से एक बार इसको बताएंगे, बट ऑब्वियसली कुछ टाइम बाद जब तक ऑडियंस भी इसको रीड कर चुकी होगी एक बार ठीक से। एंड थैंक यू सो मच सर, थैंक यू जितेंद्र सर, थैंक यू जीसीपी टीम for this wonderful deliberation and organizing this webinar on one important case law. Thank you so much sir.
एक चीज कहना चाहूंगा, प्रकाश जी को जितनी बार सुने ना सर कि और सुनते रहे। पिछली बार
Yes.
सुना था, फिर इस बार सुना, तो मतलब इंटरेस्ट इतना ज्यादा पैदा होता है सब्जेक्ट के बारे में कि भाई सुनते रहे। और केस लॉ डिस्कस करने से हमें काफी सारे सेक्शंस और बाकी अदर दूसरे एक्ट्स के बारे में भी काफी नॉलेज होती है।
और उस एक केस के अंदर कई सारे केसेस को भी डिस्कस करते चलते हैं सर,
जी
मतलब
जी बिल्कुल, बहुत बढ़िया।
खाली नाम आकर के नहीं रुकता उसका,
बिल्कुल जी।
उसका भी हमें पता लगती है। तो थैंक यू सो मच सर।
थैंक यू मैम, थैंक यू फॉर गिविंग मी द अपॉर्चुनिटी। मुझे ये मालूम नहीं अशोक शर्मा साहब अभी भी हैं बने हुए?
है सर, है।
हाँ सर है, मैंने लिस्ट में ही प्रमोट कर दिया।
आगे आगे
यस
अशोक जी
सर,
आगे।
यस
नमस्कार
सर,
अशोक जी।
यस नमस्कार सर। आप बात
Good evening,
की
sir.
है, आज मुझे प्रकाश जी का सुबह 4 बजे फोन आया था, मैसेज आया था। दैट मीन्स मे बी फॉर दिस प्रिपरेशन ही मस्ट हैव गॉट अप एट 4 o'clock। सो वो अच्छा होना ही था जब, और ये इतने 2-3 दिन पहले ही केस आया है और इतनी अच्छी तैयारी की है। टू टेल यू आई कुड नॉट गो थ्रू इट कंप्लीटली, बट देन वेरी learned a lot, that much only I can tell. Right?
शर्मा साहब, मैं एक चीज ऐड करूंगा।
Yes sir.
आपको सर आधा घंटा लेट हो गया। एक्चुअली 3:30 बजे प्रकाश जी डेली उठते हैं, नॉट ओनली फॉर द पर्पस ऑफ दिस प्रिपरेशन।
ओह अच्छा।
इनका डेली का रूटीन है 3:30 बजे का।
अच्छा डेली का, ओह गुड गुड। यहाँ पर राइट राइट, वेरी नाइस। ये तो फिर उनसे कंपेयर कर रहे हैं। ये जो चीफ जस्टिस, ये अपने जज है ना सुप्रीम कोर्ट के, चंद्रचूड़ साहब, उनका भी 3:30 बजे का टाइम है, आई एम टोल्ड।
तो परमात्मा की कृपा होती है जिनको ब्रह्म मुहूर्त में उठने का सौभाग्य मिलता है।
हाँ बराबर है, राइट राइट। हाँ मैं अभी पढ़ रहा
और
था कि 3 से 5 या ऐसा कोई
और सर
टाइम
होता
होता
क्या है कि उठते
है।
सब लोग की नींद कई बार खराब होती है, लेकिन वो लोग उसका यूटिलाइजेशन नहीं करते अच्छे पर्पस के लिए।
राइट
प्रकाश
राइट
जी
सर।
का ये कि भाई वो उसको यूटिलाइज करते हैं, हम लोग क्या है कोशिश करते हैं फिर दोबारा सोने की।
तो हाँ राइट, तो इट डिपेंड्स अपॉन हैबिट। तो अभी वी हैव टू फॉलो हिम।
जी जी बिल्कुल।
नहीं नहीं अभी करेंगे तो हम
फैंटास्टिक।
लोग। नो तो आई वाज अगस्ट व्हेन आई रेड 4 o'clock मैसेज, देन आई सेड मे बी फॉर रीडिंग दिस ही हैज गॉट अप। तो रोज ही उठते हैं तो बहुत बड़े कितना करते होंगे। वेरी नाइस, वी हैव टू फॉलो इट, वी हैव टू लर्न समथिंग।
डेफिनेटली सर।
थैंक यू प्रकाश जी, थैंक यू।
थैंक यू शर्मा साहब।
थैंक यू।
थैंक यू प्रकाश जी।
मीटिंग एंड कर दीजिए होस्ट, आई थिंक सर मीटिंग एंड कर दीजिएगा।
आप भी कर सकते हैं मैडम।
नहीं, ओनली लीव मीटिंग ऑप्शन इज देयर। ओनली होस्ट कैन एंड द मीटिंग।
जीसीपी एग्जीक्यूटिव कर रहे हैं कोई।
कर देते हैं, इट विल ऑटोमेटिकली एंड। अशोक सर प्लीज आप मीटिंग लीव कर लीजिएगा।